I arrived there, I think it was June 20th. It was a day after the special hearing for the Rosenberg case. You recall that that happened at the end of the 52 term, and it was very acrimonious, I guess. And he was very anxious to get the heck out of there, because he every year went off to Durham, to Duke University, where he got his annual physical, and he was engaged in a rice diet program at Duke. He'd had some high blood pressure problems, and he'd been fairly porky when he was Solicitor General, when he had that famous episode when he fainted in front of the Supreme Court. And so he was on his good behavior. During the year I was there, most times for lunch he ate a dish of boiled rice and a piece of fruit, usually a pear. The one thing that Reed said to me on that visit was, he said, "Are you up to date on the school segregation cases?" I said, "No, I'm not up to date." He said, "Well," he says, "when you get some spare time, see that bookcase over there? That's got all the records in it. When you get some spare time, it'd be a good idea to get up to date." I hadn't even realized at that stage that they'd entered that order of June 8th with the questions. I learned that very promptly. At that particular moment, he was planning to dissent. And he got firmly convinced that he was going to dissent, I'm sure. I mean, he didn't say it to me then, but I mean, I learned that later in the summer.
In Brown.
Oh, a dissent?
Yeah.
I never saw anything other than those yellow pages, handwritten, that he gave to me in after I'm convinced he'd already capitulated, if that's what it is, to agree to join the unanimous opinion, or up to that it was unanimous all except for your boss. That's the only thing I saw that amounted to a draft of an opinion, and I'm convinced that the reason he gave it to me was to tease me. I mean, he was pulling my leg a little bit. If he had a dissent that he was writing other than those yellow pages, nobody on earth ever saw it.
I believe that by early March he was turned around, and it was at that point that it was essentially 9-0.
I think well before, well, they had the vote in early March. I'm convinced that Warren was right, that he first said it was February, but I'm convinced it didn't happen until after he got confirmed.
Yeah.
And that happened in early March while they were in recess. And I'm sure that he was with him at that stage, but I'm sure he was with him, and Warren knew he was with him well before that. I think he was with him, and he knew, and Warren knew it on January 16th when they had that conference relating to the remedy. I mean, he was aboard.
Was he persuaded by the legal arguments? Was there some jawboning that was going on that ultimately turned him, no matter when it turned?
Oh, I'm sure there was a lot of jawboning going on. I'm sure that several of his other justices were talking to him about it. He and I were having these vigorous arguments. I kept telling him, well, isn't it the right decision? I mean, shouldn't the segregation be ended in public schools? And that's when that was the first session I had with him on it when he came back from Oyster Bay in early 1st of September. They'd been there for August, and that's when we had our first real discussion about it. And that's when he accused me of believing in critocracy.
Tell us about that.
Well, we were having this discussion, and I asked him, are they really going to overrule Plessy? He said, they've got the votes and they're going to do it. And I said, well, isn't that good? That's the right decision. And he says, I take it you believe in critocracy. I said, what? I didn't say what the hell. What is critocracy? I never heard of the word. And so he directed me to some volume on his portable bookcase that he had right next to his desk. He said, go look in that book. I don't know what I looked at, but in any event, I found out what it was. He got a big kick out of that, you know.
For the tape, explain what it was.
Well, it's law by the government by the judges. I think his decision was not based upon the fact that he was enamored of Plessy at all. He, as he said in the conference things that are well reported, he was thought the Negroes had not gotten a fair deal. He thought that what was needed was some more time because of they shouldn't be rushing into it. His other thing that he had this fixation on, that he and I argued all the time, was that this was not a equal protection question because of the historical background, that equal protection was not intended to meet this. Although he also said that he agreed that the Constitution is evolving, so Plessy may not be good law now. He used those words, I think, in one of the conferences. So he thought that if you're going to outlaw it, segregation, it should be done on due process grounds. And those were the things that were concerning him, and he finally decided that he'd go along with.
Don't you think, Jack, that the concept of unanimity, though, appealed to him also?
Oh yeah, oh yeah. The concept of not being alone to center particularly appealed to him. Because, you know, we were all anticipating that something was going to happen pretty soon because the term was coming to an end, but not specifically, and there had been no real leak amongst anybody until one of Clark's law clerks, Ellis McKay, went downstairs to the printer office that morning, and Clark's office was right next to Reed's. And of course, Ernie Rubenstein was in there, and Ellis and I had become somewhat friendly. Went down to get some opinion that Clark was interested, and he found all these packages of opinions in large quantities down there with no identification on them, and put 2 and 2 together, and came back up and told Ernie, and Ernie told me. Ernie not only told me, but I probably shouldn't tell this story. One of our classmates from Yale was counsel for the Army and was engaged in the hearings over on the Hill. John Simon, who was still on the faculty at Yale Law School, and Ernie called John, who was a very good friend of his, and said, "John, this would be a good day to come over and the court." I think he'd done that even before Tom Clark, on going out to the bench, said to Ellis and Ernie, "You guys better come out to the opinion session today." The talk I gave to the benchers in New Haven, and which was published verbatim in that Supreme Court, the yearbook, 1986 yearbook. I didn't edit it at all for that.
That speech, you kind of gave it privately. You wanted reaction from because it was a clerk talking about activities that occurred kind of behind the scenes. Were there trepidations on your part even given the speech? Oh yeah,
I thought hard about doing it, but I was having concerns at that stage about some of the publicity that was coming out about the case, and that they were getting some wrong information about, number one, amongst the liberal circles, the Yale group, Warren was getting all the credit for having turned everybody around on the thing, and the story still was that Reed had been a very reluctant convert and whatnot, and that bothered me. But I had all these